Queensland Supreme Court in 1987 there was a case between two separate yet equally important groups, Loubie, who aimed to seek justice for his right to obtain bail, and the discriminatory Queensland Bail Act of 1980. This is Loubie's story.
My name is John Dorset, and I was the justice for this case. Today I'll be telling you about the case and how it impacted the Australian Constitution.
Cheers, bros.
What's up, Stooge?
Nothing much, man. Just chilling. Thinking of smuggling some dope up the Brizzy. You wanna come?
Bros, I have 5 kids waiting for me at my New South Wales home.
But bros, it's gonna be epic.
Okay, bros, let's go.
And with that, Loubie and two accomplices flew a plane to Brisbane carrying 5 bags of heroin valued at about $30,000.
Can't believe we smuggled out that dope, bros. We're gonna be rich.
Hell yeah, bros.
Sorry, did you say you have dope? You blokes are in serious trouble.
What the bros? I do nothing.
Mate, I see you trying to get rid of this one.
Look, what I can do, the drug is mine. I got 5 kids. I'll ring my nephew in Sydney. He will get $10,000 on his house. I can give it to you. Maybe I can get the drug back. Soon as I sell it, I give you the money. Please, can I go? What about my 5 kids?
Did you just try to bribe me, mate?
No, I swear I wasn't. I swear my 5 kids, bros.
Mate, just stop. You're under arrest.
Bros, I would have gotten away with it if it weren't for you, Stooge. Oi, bros, can you give me some bail? I have 5 kids, bros.
Mate, no. The Queensland Legislation of the Bail Act of 1980, Section 16(3)(b) states that it's prohibited credit compared to a person ordinarily residing outside Queensland unless cause was shown why it should be granted.
What?
But Loubie somehow realized that the Bail Act conflicted with Section 17 of the Constitution, stating that a subject of the Queen resident in any other state shall not be subject in any other state to any disability or discrimination which would not be equally applicable to him if he were a subject of the Queen resident in such other state.
Oh, no way, Stooge. That's me?
So he decided to bring it before the Supreme Court, and therefore myself, to protect his right. You can all be seated now. Is there a Mr. Loubie here?
Yeah, bros, right here.
It's your honor to you, Mr. Loubie.
Oh, sorry, bros, Your Honor.
Okay, let's get to it. What is the case?
Bros, they were not giving me bail. I need to see my 5 kids, bros. This is a conflict in the constitution of this country, bros. And I love Australia.
Your honor.
Nah, bros, Loubie's is fine.
Mr. Loubie, please refrain from any more talking. Now, with regards to your case, by selecting residence as a criterion for applying the statutory disadvantage, the legislation chooses this exact standard prohibited by Section 117. Section 16(3)(b) was therefore invalid.
Oh, what does that mean, bros?
You can go now, you're free. Please leave and never come back.
Oh, no way, Stooge. I love you so much. I promise you, I'll never come back to here ever again. I promise for my 5 kids, bros. I love Australia so much.
As he promised, Mr. Loubie went well out of his way to never appear in my court again. In fact, he fled all the way to Lebanon to avoid punishment for his drug smuggling. The outcome of the case was the legislation being declared invalid by the justice, which is myself, and a victory for Mr. Loubie. This outcome was used as precedent for future cases and ended up having the act in question to be amended. This had a ripple effect across the entire country, with all the states taking their relevant acts. This resulted in Victoria amending their 1977 Bail Act. And this was a story all about how Mr. Loubie flipped and turned upside down the Queensland Bail Act and protected his rights in line with the Constitution. My name is Dorset, and good night, Australia.
Bros, please let me in, bros. These Lebanese stooges are gonna bash me. I confess all my crimes. No bail this time. I promise on my 5 kids. Please, bros, let me in.